Recently I received a letter from Wealden's Head of Planning and Environmental Services because they had received an application to change this bungalow. The actual plan in the application does show an extension 3,000 millimetres by 8,639.5 millimetres, requiring the removal of most of the back wall of the bungalow, but the single garage houses a worktop on one side, a sink and draining board on another side, and is named utility. Dining area has become bedroom 3, and bathroom and ensuite have changed places. The letter asked me to please send any comments on the application to the council in the next 3 weeks. A few days later I emailed my comments to the planning department, but my comments did not appear online. Why not? An email from the planning department told me that, due to the content of the representations, I am unable to immediately publish these online. I have asked the council's legal practice for advice. Soon after that, I typed Wealden Planning into a search engine and saw this at the top of the page. The Council reserves the right not to publish all or parts of documents submitted in connection with a planning application. I do not accept that Sussex Council Dictators, who for the last 20 years have contributed to the poor quality of its police, and more recently that of the police's self-obsessed commissioner, can decide what, if anything, I can say about a planning application, and so am publishing it here online. After this introduction, the rest of the video is merely what I sent to Wealden Planning. My voice can be switched off, the pause button can be pressed as soon as the next page appears, and pressed again to resume reading. You could read the comments as you do a booklet, out loud if you want to practice public speaking, or if you have one or more companions, you could read to each other in funny voices, if that adds entertainment value. I was appalled to read that conflicts with covenants are not considered to be relevant issues to comment on. Who does the considering? Presumably it's a planner or other category of council employee who regularly cautions that what he or she says is not guaranteed to be true, so I am ignoring it. If that results in my objections to this plan being ruled irrelevant, they may be published in another Wealden Planning YouTube video, and may be published there anyway in some form. I never had planning problems before I came to Wealden. Soon after I arrived, a corrupt ex-policeman called Neighbory, my neighbour at number 15, gave the person in charge of the building site a bottle of whisky to arrange fencing off part of my front lawn so that he could widen his drive. He showed me a forged land registry plan to justify the fence. Soon after, I discovered that a liar and thief named Smith of 2 Mill Villas, friend of Maybury, had fenced off part of my back garden with barbed wire to extend his own garden. Then Smith colluded with scum by the name of Hall, employee of East Sussex County Council, who also claimed to own part of my back garden. In the appalling Eastbourne County Court, in which I was initially told I could not use the court without employing a lawyer, a superannuated judge named Coltart, an incompetent dignified with the prefix His Honour, decided that he knew better than the land registry surveyor where the northern boundary of my property was, at a cost of about £8,000. After unwelcome new next-door neighbours, the Maccombes, friends of Maybury, arrived. On 2 occasions I heard Mrs. Maccombe imitate Maybury when she saw me in my front garden and pointed me out to someone with her and said, There's the little shit. Once I had occasion to post county court documents through these neighbours' letterbox. A few seconds later, the couple confronted me across their fence. Mr. McCombie's diatribe started, "Look, Madden, you wanker," and when it was Mrs. McCombie's turn, her abusive outburst started, "You motherfucker." These two claimed to own the back wall of my garage, built in 1998 and marked with a red line on my land registry plan. They attached a lamp to my garage wall and trellis which supported vegetation which was growing up into the roof space. Coltart took more than 12 months without ruling who owned my garage wall, but early on ruled that I had to pay the defendants £30 because I had not provided the court with a chartered surveyor's view of the matter. A chartered surveyor I contacted suggested that that might have cost £1,000 had he been required to attend court. After more than 12 months' sittings, Coltart ordered me to pay another court fee if I wanted the case to continue, but I didn't bother. Coltart is not the only judge I viewed with contempt. In the Hall case, a judge thought it appropriate to chat with Hall's lawyer in court. He discussed with the lawyer what I should be made to pay because the lawyer said that he had not received a copy of a ground plan that I had copied from Planning Office records. I think they decided on £160. As I had taken the plan with a letter to the lawyer's office in Eastbourne and discovered that their office staff had given the documents to a lawyer employed by Maybury instead of Hall's lawyer, she presumably added it to Maybury's case folder without even reading it, I wrote to the lawyer's office asking for my money back, as their staff were responsible for the failure for Hall's lawyer to receive a copy. The scum Mayo and Perkins refused, saying the court had awarded it to them, increasing my contempt for the profession. When a new next-door neighbour at number 9, who had presumably covenanted to limit herself to 2 cars on her private drive, sometimes allowed 6 cars to park mostly on part of a shared access way, with none in their double garage, I complained. She told me that if I wanted to get my car onto the road, I could ring her doorbell. So that Wealden Planning are given the power to agree to plans which involve shared responsibilities, and then say that they are not responsible in any way for ensuing problems, I find unacceptable. Whether a judge in court would agree with me, flip a coin to find out. Application WD 2020-1850F. This claims to be a proposal for a single-storey rear extension, but involves more than that. The block plan and site location plan both have a red line which encloses an area it does not define. Much of it does not belong to number 15. It was not copied from the land registry plan of the property. It does not show the private drive. The land registry deeds for my own property include restrictive covenants which govern how a large area of that enclosed by the red line in the application is used. It is cross-hatched and labelled shared access rights. I am allowed to park 1 car temporarily on the area which the deeds show to be my private drive. When I signed the deeds, I agreed not to park more than 1 car on my drive or any outside my garage on the private land from September 1998 and for the next 57 years from now. I would not necessarily accept anything in land registry papers which had been in the possession of Maybury, though the forged plan that he had shown me in January 1999 had been on a separate sheet of paper. The number of cars allowed to be parked on private drives and not on the rest of the private land is relevant to item 8 on the Householder Application for Planning Permission for Works or Extension to a Dwelling document. 8. Parking. Will the proposed works affect existing car parking arrangements? No. That choice appears to be untrue. The proposed ground floor plan has additions which would make most cars too long to park in the garage. The private driveway of number 15 is restricted to the area covered in pavers by Mabry and his son, starting a few days after my land registry documents arrived and I asked Mabry to remove his fence. The single garage might mean that only a single car is allowed on the drive. I am also concerned about the nature, size and position of the proposed extension. In the past, I have been disgusted by Wealden Planning Department's tolerance of dishonest applications. A few years ago, an agent belonging to CKA Architectural Cons Limited was involved in a dishonest application to build houses overlooking my property. A village garden next to grass and trees did not constitute a brownfield site, and investigation of ownership of the land on which a two-storey bungalow was built was very inadequate. CKA Architectural Consultants Limited, who even misspelled their own name, claimed in substandard English that the properties have been designed such that there will be no overlooking to neighbouring properties. None of the windows to habitable rooms at first floor level will face the adjacent dwellings. In the UK, first usually means what in US English is called second. Now the inside of my bungalow and my back garden can be looked down on through more than a dozen panes of glass. My back garden through two more obscured panes of glass in a two-storey bungalow having been replaced with conventional glass when the planning hurdle had been dishonestly cleared. Two more panes of glass in a new garden shed behind my garden and close to a fence, overtop that fence directly opposite my two living rooms. Numbers 11 and 15 were built on a hill, on ground which rose from the back of the bungalows up to Stone Cross Windmill. Mabry removed many tons of earth from his back garden to flatten it and install a small overground swimming pool. He and his son built brick walls to hold up my back garden and much of the land behind number 15 before two semi-detached houses were built on it. I could not have tried to prevent Mabry building his wall. When I asked Mabry to move his illegal fence from my lawn, he said, "You're a little shit," and his wife called me a neighbour from hell. Mabry only removed part of his fence. I asked the judge in Eastbourne County Court if I could remove the rest of it myself. The judge agreed that I could. When I did so, Mabry assaulted me repeatedly and knocked me to the ground on my drive. What passes for a police force in Sussex would not allow me to make a signed statement about the assault unless I agreed to drop the matter. Though I had previously told the police of various forms of harassment, such as hundreds of letters through the post, goods ordered in my name, threatening telephone calls, and telephone calls in the middle of the night. The calls included orders to move house or else, an order that was repeated by Mabry's friend Maccombie when the Mabrys and the Maccombes and two supporters smashed their way into my back garden. 3 of the gang assaulted me, and Mabry arranged for me to be arrested by 2 corrupt police officers who appeared in a YouTube video called The Laughing Policeman Updated by GGM11. The position of Mabry's fence is shown in another YouTube video by GGM11, Retirement in Sussex, Part 1. When the wall at the back of number 15's back garden started bending, the third owner of the property had it rebuilt. The wall next to my property is still in place, but it replaced 6-foot wooden fencing put up by McAlpine, and was put up with such lack of foresight that when the third owner of number 15 had new fencing panels installed, he was unable to have the panels put on top of the wall, and so one panel is only 4 feet above my garden at its lowest point. As a result, from the north of my back garden, the back wall of number 15 and its glazed windows and doors are visible, a situation that I dislike both as viewer and viewed. Number 15 is supported by ground and foundations higher than number 11's equivalents. Number 15's wall between the properties is 26 inches high, and the fence panels on top of that are 6 feet high. The guttering of number 15 is higher than the top of the panels, and the top of the proposed extension is well above the present roof's gutter level, and extends above the top of the fence for more than 3 metres, and even more than that from the rear wall of my bungalow, and would be detrimental to the view. My sight of the bungalow windows and doors would be worsened also with the change to 5 fully glazed doors through which part of my back garden could be observed. The doors and the windows would be 3 metres nearer to the end of my back garden and even more detrimental to my use of it. Addendum. My brother, a chartered architect and professor of architecture, told me that a planning application for a property was required by law to indicate with a red line its actual area, and that I should send Wealden Planning a copy of the land registry plan which is in the deeds of my property. That plan should be included in the deeds of 9 and 15 Blatchington Mill Drive. Just after being told that, on the 2nd of October 2020, I found a Rightmove web page on which the bungalow is described as Sold STC by Fox and Sons. A paragraph of description includes the untrue puff. To the front there is a driveway with off-road parking for several vehicles. That is clearly a lie. In this planning application, the actual drive is not even shown. A similar off-road online lie was told by a Stone Cross estate agent who was selling number 9 about 5 years ago. I telephoned the agent and complained, but the spokesperson told me that off-road parking meant on the drive. I think that Wealden should disallow this application unless it is made lawful. If it is unlawful, only evaluate a lawful application and investigate whether the application is a scam and the would-be purchasers innocent victims of others who should be prosecuted. Wealden should also enlighten the would-be purchasers if they think that the applicants are being scammed.